Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
From safe. Dahil mihi Anglican po in verbal.
Is that correct?
I didn't ask you to interrupt me.
That's literally not true.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. In a special lunchtime edition, we have a new document to read. Let's see if I can get this pulled up here. It says 147 pages. We're not going to have all those read, and a lot of them are exhibits, so don't worry. We're going to keep you guys entertained and informed all at the same time. Let's see, page 7. What's that doing? I told you many times that I'm fascinated by the Karen Reed case and where it's at, but not really excited about the drama that surrounds the case. I wish I could just watch the case without that drama. This is just case, no drama. And so we're going there. Let's see, we need continuous scroll. There we go. All right. It's all set up. We're good. Welcome back. Especially a big thanks to, was it Whiskey Brand?
Happy birthday.
Or Special K?
Good.
Special K, you were the first person in chat. I do see Whisk Brand with a... It's cleared off. I can't see it. Special K, first person in chat every time is punished. Yeah, it's not a good. Well, it's good for us. It's not a good thing for you. Your exuberance of being in chat. We want to punish you by sentencing you to internet ownership. So you're responsible for fixing everyone else's internet issues worldwide. Special K is the owner. Yep. Congratulations, Special K. You can add this to your resume if you want. It works. You can actually download a certificate of internet ownership from our portal, the shopping portal on the YouTube channel. It's 50-cent fine. That's all you have to pay to get a copy of that record. And just fill in the blank. It's already pre-signed by myself and my boss, Mrs. R.A., suitable for use as a cover sheet or for framing even. Cover sheet for your CV. All right, let's see. We're going to jump here really quickly to this because that's what you guys came for. Michelle's Mixed Media Madness, so happy to be here today, even for a short time, but wanted to send this message to say hello. Michelle's Quad M, what, 4M squared, what is this? M to the fourth? I don't know what we're going to call you.
Kick back,
it's a mouthful. Thank you. Taz gifted 5 memberships to kick things off as well. Thank you, one and all. Please do, if you've got a membership, please take a seat so people behind you can see. Just type ! seat like that right there. If you remember, you'll be ushered right up to your front row seat, and you'll have a view with all your friends there as well. All right, this is going to be interesting. Let me bring you the document without further ado, because, that's what we're here for, and lunch only lasts so long. We're on lunch break for the Todd Mullis thing, and even though it's an hour and a half, I've got a lot of pages to read during that time. If I go too quickly, buffer me or something, okay, mods? So I can slow it down. But this is my understanding on this document. First of all, thank you to our amazing mods, Amber, who is a mod on our channel, as well as over on the Discord channel, As the Gavel Drops. This is the place you can get all these documents. Pretty much hot off the press, that's how they land in the Discord page. She alerted me to this.
In front of the Walmart.
Thank you very much. In front of the Walmart. And it has been redacted. This is a redacted version. That looks like Bev handwriting all over the top of that. So this document, I think as soon as it was immediately redacted when it was filed. I thought it was by Bev. I'm not sure. But this is to the Superior Court. The Superior Court. They're going above and beyond and saying, look, we need this to be thrown out, and here's why. So I'm here for it. Let me just get it on the page so we can all see. Are you guys able to see this right here? I have my water. You guys can have lunch while I read it. The Superior Court has already weighed in on this case, I believe, once before, specifically with the did the jury reach a verdict question. But this is a new question for them to be weighing in on. So here we go. Defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. Those are not words you throw around lightly as an attorney. Now comes the defendant, Karen Reed, hereafter known as Miss Reed, and respectfully moves this honorable court pursuant to Article 12 of the Massachusetts Declaration of Rights, the 5th, 6th, and 14th Amendments to the United States Constitution, and Massachusetts R. Crim. P. 14C, to dismiss all charges with prejudice, which means they cannot be refiled, on the basis of extraordinary governmental misconduct. See the U.S. Constitution Amendment 5, U.S. Constitution Amendment 6, U.S. Constitution Amendment 14, Article 12 of the Declaration of Rights of the Massachusetts Constitution. It's all the citations here, okay? A prosecutor, quote, may strike hard blows, but he is not at liberty to strike foul ones. It's a tiny bit hot. It is as much his duty to refrain from improper methods calculated to produce wrongful conviction as it is to use every legitimate means to bring about a just one. Throughout the course of these proceedings, Ms. Reed has been severely prejudiced by Commonwealth's pervasive misconduct. The Commonwealth has suppressed discoverable exculpatory video surveillance from the Canton Police Department. It has provided piecemeal disclosure of some footage, most of which was disclosed after the trial started, and after the Commonwealth represented that all video footage had been provided to the defense. For reasons that remain unexplained, much of the video that has been disclosed is missing critical timeframes and evidence central to Ms. Reed's defense. Some of the video clearly appears altered or manipulated, as evidenced by people appearing and disappearing out of nowhere. At the first trial in this matter, Assistant District Attorney Adam Lally, ADA Lally, brazenly introduced inverted video and elicited patently false testimony from Sergeant... I always want to say this name wrong. I'm sorry. Yuri Buchanan, that the video was fair and accurate, and was a fair and accurate depiction of critical events in an attempt to falsely insinuate to the jury that no member of law enforcement ever approached, touched, or otherwise disturbed the rear right taillight of Miss Reed's SUV. There can be no doubt that this video and false testimony was offered to mislead this court, the jury, and the defense by making it appear that MSP Trooper Michael Proctor, hereafter known as Trooper Proctor, was standing next to the left rear taillight when the Commonwealth knew the exact opposite was true. Trooper Proctor was, in fact, standing directly next to the right rear taillight. Other Sallyport video, which was unquestionably unfavorable to the defense because it would have severely discredited key witness Brian Higgins, inexplicably, I don't know what sound do I make for the redacted part. Inexplicably was not disclosed to the defense until months after the first trial. To this day, the Commonwealth's failure to explain the disturbing circumstances surrounding their disclosure of the exculpatory Sallyport video and why some video was suppressed from the defense at the first trial has made a mockery of Mrs. Reed's right to due process. The Commonwealth exploited... Amber's calling in. Am I doing something wrong? Hey, Amber, how's it going?
Yeah, something's wrong, and I got to correct you just real quick.
Okay.
So this is... It's not to a higher court. This is actually to Judge Bev. This is for her criminal case.
That makes more sense with her redacting it then. So,
yeah.
So this was the document that was filed the other day, and immediately the court impounded it, right?
Correct. So this is not going to a higher court. This is going in front of Judge Beverly Canoni.
So it's going in the trash, is what you're saying?
No, I don't think so. I think they have all of their legal arguments that I don't know if she's going to have a choice to either grant mistrial, which I don't think she's going to do, or give them the alternatives that they're asking for, and I'm not spoiling it. It's down at the bottom.
Okay,
You'll get there.
thank you. Thank you. We'll get there. We've got
You're
30,
welcome.
30 some odd pages. Thank you. I misunderstood that. I was doing this while doing the other thing. Thanks. This is why I have great mods to correct me when I make a mistake. So I apologize for my inaccuracy. Amber, thank you, and you can go back to work.
Thanks.
All right.
Bye.
Bye. Thank you, Amber. Appreciate that. I do apologize for that mistake. That's a big one. Yes, that's correct. All right. This has made a mockery of Mrs. Reed's right to due process. The Commonwealth exploited this court's order, instructing the defense to disclose its impeachment material in advance of witness testifying. ADA Lally and MSP Lieutenant Brian Tully, hereafter Lieutenant Tully, huddled with key witnesses. Huddled with key witness Jennifer McCabe, mid-trial. Oh, why did she just get last name? Everyone else got like two code words, and she just got McCabe. Mid-trial, prepped her on how to explain why she never disclosed that she went to Canton Police Department Sergeant Michael Lanks, hereafter Sergeant Lanks, home one day after John O'Keefe's death, and then suppressed exculpatory statements made by McCabe during that session until nearly a month after McCabe's testimony, at which point McCabe and other relevant witnesses were safely off the witness stand. If the Commonwealth had complied with their obligation to provide statements of witnesses before they testified, the defense would have been positioned to expose McCabe's material, inconsistent statements about her meeting with Sergeant Lank. Redaction. As a result of the extraordinary governmental misconduct, Miss Reed has been permanently and irreversibly denied her constitutional right to a fair trial. No remedy other than dismissal can adequately address the significant harm caused to Miss Reed and the injustice of proceeding without the lost exculpatory evidence that was in the Commonwealth's possession. Redaction. Accordingly, the case against Miss Reed must be dismissed with prejudice. Here are the statement of facts. First, Miss Reed is accused of the following crimes arising out of the death of Officer O'Keefe, Officer O'Keefe. Murder in the second degree in violation of Massachusetts law, manslaughter while under the influence of alcohol, that's count 2, and leaving the scene of personal injury and death in violation of the law, count 3. A months-long jury trial was held in this matter beginning on April 17th, 2024. We were there. On June 25th, 2024, the jury began deliberations. After the jury submitted a note to the court indicating that the jury was at an impasse, the court declared a mistrial on July 1, 2024. The Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury in a case in which the jury either voted to acquit or was deadlocked on the lessers of one charge. There is no cure, short of dismissal with prejudice, that can remedy the serious constitutional and statutory violations that have occurred in this case. The facts relating to their respective misconduct and discovery violations are set forth below. Before we do that, let's read the footnote. In the days and weeks following the first trial, 5 deliberating jurors have come forward and indicated they had unanimously acquitted Miss Reed on counts 1 and 3 and were hung only with respect to count 2. They indicated they did not believe they were permitted to report the unanimous decisions on counts 1 and 3 unless they were able to reach a unanimous verdict on all counts. Miss Reed's failure to address any claims of double jeopardy in the instant motion to dismiss shall not in any way be deemed or construed a waiver of those issues, which are presently pending before the United States District Court for the District of Massachusetts. Okay. Facts relating to the destruction and withholding of exculpatory Canton Police Department video surveillance footage. This court is aware of the critical importance of the video surveillance footage from the Canton Police Department on January 29, 2022. The Commonwealth has produced dribs and drabs, there's a legal term for you, of various clips of video surveillance obtained from the Canton Police Department's ExactQ Vision DVR system from January 29, 2022, without any accompanying reports, evidence logs, or other documentation regarding the recovery and chain of custody of this evidence on at least 4 separate occasions. Relevant discovery orders. On February 2nd, 2022, the defense filed defendant's emergency motion for preservation of evidence, including the preservation of all physical evidence such as video surveillance footage, with the Stoughton District Court. That's the other court, February 2nd, 2022. Order on motion to preserve evidence. At February 2nd, 2022 hearing, ADA Lally stated in open court that he had reviewed the proposed order and had no objection to it. That same day, the district court issued a preservation order for all physical evidence, which includes video surveillance footage. In other words, 3 days after O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in its possession, custody, or control, which included the Canton Police Department and or Massachusetts State Police, and ADA Lally was required to notify law enforcement of this order. On September 16, 2022, after Miss Reed's case was transferred to Norfolk Superior Court following her June 9th indictment, the defense filed a separate motion to compel the production of certain outstanding discovery, including all crime scene photographs and or videos taken in connection with this case. There's an Exhibit B that'll have that. That October 5th order on defendant's motion to compel. On October 5th, 2022, this court granted the motion to compel, in part, and ordered that the Commonwealth produce all video evidence and metadata associated with the videos on that date. Part 2, dates of production and facts relating to discovery and constitutional violations. The Canton Police Department's video surveillance footage has been in the Commonwealth's possession, custody, and control since January 29, 2022. Redacted. Why are we redacting who has custody of the video? Can I just say this should not be sensitive information. Notwithstanding this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years, failing to disclose even the first incomplete batch of the footage until the eve of the first trial on April 4th, 2024. The Commonwealth has now produced 4 separate, incomplete batches of video surveillance footage recorded at the CPD on January 29th, 2022. It's pronounced Stoughton. Stoughton instead of Stoughton. Okay. April 4th, 2024 production. On April 4th, 2024, on the eve of the first trial in this matter, the Commonwealth for the first time disclosed, woefully incomplete, CPD video footage, which consisted of video from the CPD main driveway and CPD Sallyport front wall cameras from January 29th, 2022. Curiously, the Sallyport front wall footage omitted a 42-minute interval at the precise time the SUV arrived at the Sallyport garage. Sallyport front wall footage. The missing footage from the Sallyport front wall camera would have captured a close-up of the condition of the SUV's right rear taillight upon arrival at the CPD's Sallyport garage. The individuals who had access to the rear taillight and whether anyone removed taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview Road. The condition of the rear taillight of the Lexus SUV at the time it entered law enforcement custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way, in violation of the February 2nd, 2022 preservation order, which means the defense had been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost critical video evidence in its possession that it was obligated to preserve. Part B, April 10th, 2024. The Commonwealth filed its Certificate of Compliance. On April 10th, 2024, the Commonwealth filed a Certificate of Compliance in which ADA Lally certified to this court, 6 days before trial, that the Commonwealth, after exercising reasonable inquiry and due diligence to the best of their ability, disclosed and made all items subject to discovery. April 10th, 2024, Certificate of Compliance. Emphasis was added by the defense. This representation was patently false. It means it's demonstrably false. It strains credulity that ADA Lally, in light of his actual knowledge of the preservation order and existence of extensive Sallyport video, would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discoverable material in his possession, custody, and control. At a minimum, rather than mislead the court and the defense, ADA Lally was obligated to inform the court and the defense that there was outstanding video surveillance footage. A party may not fail to make a reasonably diligent effort to comply with a legally proper discovery request. Part C, April 23rd, 2024. The Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched otherwise manipulated the rear right taillight of Miss Reed's SUV. Redacted. Footnote says ADA Lally was cognizant of other discoverable material that the Commonwealth did not disclose before certifying his compliance with his discovery obligations. Notably, when filing the certificate of compliance, he expressly represented that the lone exception of outstanding discoverable material was some evidence related to DNA testing and analysis. More redaction. On April 23rd, the Commonwealth produced additional footage from the CPD Sallyport back wall via a share link entitled Additional Sallyport Video Download Link. No flash drive was presented to the defense. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury that nobody approached or touched the rear taillight of Miss Reed's vehicle after it entered the Sallyport. Hey, Mrs. R.A., how you doing? She brought me a plate of chicken. It smells delicious. I'm not sure if I can eat this. Oh, that smells so good. I'll have it cold later, I guess. Love you. Thank you. It's the thought that counts.
Did you just passive-aggressive this?
No, I really appreciate you.
Oh, okay.
I do. She's awesome. She made me lunch, knowing that I was not taking a break. Okay. After it entered the Sallyport, ADA Lally craftily elicited testimony from the sergeant mechanic that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the CPD on January 29, 2022, and that, as seen in the video, no law enforcement officer approached the right rear tail light. On cross-examination, however, Sergeant Buchanan's testimony was exposed as profoundly misleading at best and perjurious at worst. It became apparent that the video surveillance displayed on direct examination was inverted and a mirror image of reality. Critical facts which neither ADA Lally nor Sergeant Buchanan saw fit to inform the court, defense, or jury.
When are we going to break for lunch?
We're not. In other words, this video made the left side of Miss Reed's SUV appear to be the right. The Commonwealth never filed a supplemental certificate of compliance. As the right, and the right to appear to be the left. Therefore, the video presented to the jury as fair and accurate appeared to show a person, Trooper Proctor, standing near the left rear taillight of the vehicle, when in fact Trooper Proctor was standing near the right rear taillight, i.e. the taillight at issue. Moreover, the inverted video does not capture the condition of the rear taillight, and it conceals Trooper Proctor's presence by the right rear tail light. This leads to inescapable conclusion that ADA Lally's questions, Sergeant Buchanan's responses, and the deliberate introduction of inaccurate evidence was designed to perpetuate the fraud on the court, the jury, and Miss Reed with respect to the critical issue in the case. Those words, perpetuate a fraud upon the court. These are bold, bold assertions. This is not something you say lightly. Amber wants me to pin this message. Hang on. We are reading a hot off the press new document in the Karen Reed trial. It was impounded by the judge and redacted by the judge, and it's just now been released, and we're bringing you all of it here on this lunchtime. So buckle up. All right, where did we end up? I'm looking for my mouse. It's up here. There we go. October 10th, 2024, the Commonwealth produces additional exculpatory video surveillance footage in violation of Brady and Rule 14. Post-trial, that means after trial, on October 10th, 2024, the Commonwealth again provided new footage, this time from the CPD church-side exterior, first floor corridor, rear lot main side, and rear lot cruiser side cameras. This footage shows Higgins arrive in the parking lot at the CPD at 1:26 a.m., enter the building, and speak to some unidentified individuals on the phone as he's leaving the CPD at 1:30 a.m. Significantly, this specifically requested material and the relevant evidence which establishes that Higgins was on the phone with some unidentified individual at 1:34 a.m. as he left the CPD shortly after John O'Keefe's death was suppressed until after the first trial. Redacted. The Commonwealth failed to preserve exculpatory video surveillance from January 29, 2022 in violation of a court order and Brady. On November 8th, 2024, while preparing for Miss Reed's second trial and in response to the continued... Hang on. See who this is.
Call from
the Bostonian speaker.
To accept, press 1.
Hello, Bostonian speaker. This is RA. You're live on the air. How you doing?
Hey, what's going on? Listen, I want to correct you because we got to teach you how to speak Massachusetts in. All right?
You've got a tough road to hoe there.
All right, it's pronounced Stoughton.
Stoughton, not Stoughton.
Good. Yeah, pronounced Stoughton. Make it easy, like you're towing it, but it's Stoughton.
Stoughton. Okay. When it comes up again, I'm going to mispronounce it again, and you can remind me, and then I'll remember.
That's okay.
So
that sounds good.
Thanks for the correction. Right. I appreciate the call. All right.
Goodbye.
Bye. I'm going to learn. One day I'll learn how to read and speak correctly. So while preparing for this second trial in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, attorney Elizabeth Little emailed Special District Attorney Hank Brennan, 88 Brennan, again requesting inter alia all raw video footage from the CPD, which shall include but is not limited to all cameras capturing the interior of the CPD and or the exterior of the CPD, including all the parking areas, entrances, and exits and garages between January 29th, 2022 at 12 a.m. and January 29th, 2022 at 11:59 p.m. We want the whole day, 24 hours of footage. On November 25th, 2024, 88 Brennan indicated via email that he would request that CPD provide all the requested footage. So hang on. She asked for this on November 8th. On November 25th, he says, I'll ask them. So 3 weeks later, basically. Ultimately, the defense requested access to the CPD DVR system and drives that hold recordings from the security camera system so that defense expert Matthew Erickson could obtain video files and corresponding log files from January 29th between 12 a.m. and 11:59 p.m. Upon reaching an agreement with the Commonwealth, Matthew Erickson visited the CPD on the morning of December 12th to image the DVR system. He then discovered, as the Commonwealth has since conceded, that the DVR system was programmed to automatically overwrite footage after 30 days, which means that the Commonwealth failed to preserve specifically requested material and exculpatory footage relevant to Miss Reed's case via standard forensic protocols, as they were obligated to do pursuant to the February 2nd, 2022 preservation order on October 5th, 2022, and October 5th, compelling the discovery of all videos and related metadata. Okay, so it was set to erase after 30 days. On February 2nd of 2022, they were told to protect that, which was just days afterwards, because it happened on January 29th. So they had time to do it, and they did not. But just think this one through. If the video files erase themselves after 30 days, that means they extracted these and had them in their possession, extracted from the machine within a month, and then they didn't turn them over. It's not like they found these and went back and found them. They would have been deleted for them as well. So they had all these and sat on them. So the turning over the discovery late is very, very bad. January 28th, 2025, the Commonwealth produces more exculpatory blurry video surveillance footage establishing that an unidentified person approaches the rear taillight of the SUV as soon as it enters the Sallyport garage. On January 28th, the Commonwealth yet again, this is 2025, this is this year, a month ago, the Commonwealth yet again turned over additional CPD surveillance footage. How are they getting more if it deletes after 30 days? This time from an exterior camera depicting Miss Reed's SUV being brought into the Sallyport garage. Main driveway side, exterior Sallyport. It's an executable? It's an executable file? That's crazy. The footage, although blurry and grainy, appears to show an individual approach the rear right taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport garage and then exit shortly thereafter. If this video were not blurred out, the surveillance video surveillance feed would have captured yet another angle of the rear taillight as it entered the Sallyport garage. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time the right rear taillight of the Lexus SUV should be in frame upon its arrival at the Sallyport. This angle of the video surveillance is exculpatory and was withheld from the defense prior to the first trial. I think that's their best argument so far. Facts relating to the Commonwealth's intentional withholding of exculpatory statements made by seminal witness Jennifer McCabe. McCabe is a key Commonwealth witness. Her credibility is critical to the Commonwealth's case. On February 2nd, 2022, mere days after O'Keefe's death, the MSP, Massachusetts State Police, obtained and forensically imaged McCabe's cell phone. The forensic examination of McCabe's cell phone revealed significantly exculpatory evidence supporting Miss Reed's third-party culpability of defense, inter alia, establishing that McCabe Googled "Hoss long to die in cold" at 2:27 a.m. on January 29, 2022, 3 hours before she supposedly discovered Mr. O'Keefe's hypothermic body in the snow on her brother's lawn, Brian Albert's front lawn. McCabe then took steps to delete that one search out of more than 4,560 on her phone, along with nearly every communication made on her phone in hours following O'Keefe's death, only some of which were recoverable from her phone using forensic extraction software. The close and long-standing relationship between Albert and the McCabe families and the law enforcement officers assigned to investigate this case is central to Miss Reed's third-party culpability defense. CPD Sergeant Link, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29th. In preparation for trial, the defense uncovered location information on McCabe's cell phone, which proved that she went to first responding officer Sergeant Lake's home on January 30th, the day after O'Keefe's death. Redacted. On May 7th, 2024, in accordance with this court's order that parties disclose all information to be used for impeachment purposes, Attorney Little emailed ADA Lally and ADA McLaughlin to provide location information from McCabe's cell phone, establishing that she went to Sergeant Lake's house on January 30th, 2022. Unbeknownst to the defense, ADA Lally and ADA McLaughlin shared this impeachment information with Lieutenant Tolley. On May 10th, 2024, in a then undocumented meeting, Lieutenant Tolley, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify in the first trial. McCabe's materially inconsistent statement about meeting Sergeant Link was not memorialized in any report or otherwise disclosed to the defense in advance of McCabe's testimony at trial in violation of Brady, Giglio, and Rule 14. Giglio makes me giggle. Giggity. McCabe testified beginning on May 17, 2024, during cross-examination on May 22, 2024. She testified that she received a text from her sister, Nicole Albert, on January 29, 2022, stating, "We'll get more info tomorrow. Don't want to text about it." To which she responded, "Right." When Miss McCabe was asked whether anything significant happened the next day, January 30th, McCabe volunteered the following story. "I went to the O'Keefe's house. On the way home, Carrie Roberts' daughter is good friends with Michael Lank, so we dropped her off at Michael Lank's house. And Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asked how the O'Keefes were doing, and, we talked to her." She testified that she was at the house for approximately an hour and that she might have run in to go to the bathroom. Redacted. On cross at trial was the first time McCabe mentioned going into Sergeant Lake's home on January 30th, 2022. When pressed further, she admitted that she had discussed this issue at a meeting a couple weeks prior at the DA's office. The problem is not that she went in the house, although that would be something the defense would want to target. The problem is that the defense knew about it and then didn't turn that information over. She testified at the meeting at the DA's office. I was asked, were you at Michael Lank's on the 30th? She admitted that at first I said, no, I've never been to his house. Then I thought about it and said, oh my gosh, yes, I did go there, and that was the extent of the conversation. She further testified that 1, Tolley did not ask her any follow-up questions about why she went to the personal home of Sergeant Lank the day after O'Keefe's death, and 2, that he did not take any notes. On May 29th, only after the defense was deprived of the opportunity to effectively cross-examine McCabe and Carrie Roberts about their visit to Sergeant Lank's house, Lieutenant Tolley memorialized his meeting with McCabe. A report of Tolley's interview with McCabe, that's the exhibit, Notably, Lieutenant Tully memorialized McCabe's consistent claim that she went to Sergeant Lake's home to pick up Carrie Roberts' daughter. Ooh, that's inconsistent. Pick up or drop off. Lieutenant Tully's May 29th, 2024 report, which also omitted any reference to McCabe's exculpatory statement in which she denied that she ever went to Sergeant Lake's house, was not disclosed to the defense until June 4th, 2024. This next whole section is redacted. There's a whole part here. Everything, possibly another section. Let's look at the spacing here. C is not redacted, so we know section C is there. Let's look and see if we go straight to D. We don't know. There might be C, D, E. I don't know how much was there. I'll redact it. Part 2, argument. The Commonwealth has engaged in numerous Rule 14 discovery violations and constitutional violations under Brady versus Maryland and its progeny. I like words like progeny. Misreads constitutional rights to effective assistance of counsel and to due process under the law, as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendments of the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial. Case law or citations. Defendants have an unquestioned right under the 6th Amendment and Article 12 of the Massachusetts Declaration of Rights to obtain relevant evidence that bears on the question of his guilt or innocence or which otherwise helps his defense. Pursuant to Brady versus Maryland and its progeny, the defense counsel is entitled as a matter of due process to all evidence that is favorable to the accused and material either to guilt or to punishment, including impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and his credibility to a test. Brady disclosure also extends to disclosure of information useful to the defense to attack the reliability of the police investigation and the police methods employed in assembling the case. Everyone got your red Solo cup? Here we go. In addition to her constitutional rights, Ms. Reed has a statutory right to obtain evidence in advance of trial and prepare for her defense. Massachusetts Rule of Criminal Procedure clearly state that the Commonwealth must provide certain mandatory and automatic discovery of evidence within the possession, custody, or control of the Commonwealth to the defense in order to meet its mandatory discovery obligations. As amended, here's the law as amended. Information subject to such mandatory discovery includes all material and relevant police reports, photographs, tangible objects, all intended exhibits, reports and physical examinations of any person or scientific tests or experiments, and statements of the persons the party intends to call as witnesses. The Commonwealth is also required to provide any facts of exculpatory nature. The rules also state the defendant may move for discovery or of other material and relevant evidence not required by this rule. Here on February 2nd, 2022, the Commonwealth was ordered to preserve all physical evidence, including video surveillance footage from the Stoughton, did I say that right? Stoughton District Court. Exhibit A shows that. Subsequently, on October 5th, 2022, the court ordered the Commonwealth to produce all videos in connection with the case and associated metadata. Notably, this prosecutorial duty to produce evidence uncovered by Rule 14 extends beyond just the prosecutor to all agents of the Commonwealth, including police. The prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. A prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation and presentation of the case. The note here is notes to the law. The provision requires the prosecution to provide automatic discovery of any facts of exculpatory nature. Automatic means that the defense does not have to ask for it. It has to be turned over to them just as soon as it's found. Basically, when there's discovery, it gets turned over. It derives from the constitutional requirement established in Brady that the suppression of the prosecution of evidence favorable to an accused upon the request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. This duty is also an ethical one imposed on the prosecution by Supreme Judicial Court Rule or Superior Judicial Court rule. I think that's what it is. Internal citations omitted. As set forth herein, the Commonwealth has repeatedly violated its discovery obligations under Brady versus Maryland and its progeny and Rule 14. Stoughton. Did I say Stoughton right? Did I say Stoughton again? Did I say it wrong? Stow like toe. Stoughton. All right, I'll get it eventually. The Commonwealth's production of the April 23rd, 2024 inverted video from the Sallyport garage violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence. First, the Commonwealth violated Rule 14 and this court's October 5th, 2022 order compelling the production of video evidence by withholding the inverted video from the Canton Sallyport until after the start of trial and after the Commonwealth had already filed its certificate of compliance on April 23rd, 2024. At best, the inverted video had been in the Commonwealth's constructive possession since January 29th, 2022. See, they brought that out. It would have been deleted after 30 days. They had to have had it within the first 30 days. At worst, this video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the right rear taillight of the defendant's SUV upon its arrival in the CPD Sallyport. Either way, the Commonwealth's production of the inverted video in the middle of trial and after it filed its certificate of compliance violated Rule 14. The Commonwealth violated Rule 14 and Brady by withholding exculpatory impeachment evidence establishing Higgins was speaking to some unidentified individual on the phone at the CPD at 1:34 a.m. on January 29th, 2022. I'm not sure how that's exculpatory. It would be fringe. Basically, police officer on the phone at the police station early in the morning before O'Keefe's body is found. After trial in this matter, on October 10th, 2024, the Commonwealth produced previously withheld video surveillance. This is crazy. After trial on this matter, the Commonwealth produced previously withheld video surveillance. That is so wrong. From the CPD's church side exterior and rear lot cameras, which show Higgins arrive in the parking lot of the CPD at 1:26 a.m., enter the CPD, and speak to some unidentified individuals on the phone as he's leaving the CPD at 1:34 a.m. The Commonwealth, namely ADA Lally and ADA McLaughlin, suppressed exculpatory impeachment evidence, redacted. Any evidence which tends to impeach the credibility of key prosecution witness is clearly exculpatory. This exculpatory video surveillance footage was in the Commonwealth's custody and control since January 29th, 2022, and at the time of trial was in ADA Lally and ADA McLaughlin's actual possession. This is not something like, oh, the police department discovered they had these. No, Lally had this in his pocket, is what they're saying. Lally had this video in his pocket during the trial and had not turned it over, and then tried to use it as evidence during the trial. It's the first time they saw it. By withholding this exculpatory evidence and failing to produce this information until after the trial, this is the second one. This is the one he kept and didn't show. ADA Lally and ADA McLaughlin's violated Miss Reed's constitutional rights as set forth in Brady versus Maryland and its progeny. Order compelling the actual production of the ethics duties imposed by prosecutors. There's the rule. Part 3. The Commonwealth violated Rule 14 and Brady by withholding exculpatory video surveillance footage establishing that an unidentified person had unfettered access to Miss Reed's right rear taillight of the SUV immediately after its arrival in the Canton Sallyport garage. Last month, on January 28, 2025, the Commonwealth provided additional CPD surveillance footage from January 29th, this time from an exterior camera, depicting Miss Reed's SUV as it was driven into the CPD Sallyport garage. This camera angle should have had a clear and unobstructed view of Miss Reed's taillight as it was driven into the Canton Sallyport garage. However, yet again, the footage is too blurry and grainy to make out the condition of the taillight. Notwithstanding that fact, the footage is exculpatory and shows an individual approach the rear right taillight. Why can I not say right rear? Why do I have to say rear right? The right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the sally port and then exits shortly thereafter. This video surveillance footage has been in the Commonwealth's possession since January 29th, 2022, and was withheld from the defense for 3 years and only produced after trial in this matter. This video surveillance footage directly contradicts Sergeant Buchanan's false testimony at trial, in which he claimed that video surveillance established that no one from law enforcement approached the right rear taillight of Miss Reed's vehicle. Miss Reed's defense at trial in this matter was that law enforcement removed taillight material from the Lexus SUV and placed the evidence at 34 Fairview Road. Notably, no taillight material was found at the crime scene until after the Massachusetts State Police took custody of Miss Reed's vehicle and after it arrived at the CPD sally port. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory. As such, ADA Lally and ADA McLaughlin violated Miss Reed's constitutional rights as set forth in Brady v. Maryland and its progeny, mandating the disclosure of exculpatory evidence, and the court's order compelling the production of video evidence and the ethics duties imposed on prosecutors by the rule by withholding this video surveillance of footage from the defense at trial. Part 4. The Commonwealth failed to preserve exculpatory evidence in violation of the court order. The CPD and the Norfolk County District Attorney's Office failed to preserve material and exculpatory video surveillance footage and associated logs in violation of the Stoughton District Court's February 2nd, 2022 preservation order and this court's October 5th, 2022 order compelling the discovery of all videos in the Commonwealth's possession and related metadata. Moreover, the metadata and log files underpinning the CPD surveillance footage from January 29th are clearly exculpatory, and thus the Commonwealth had a constitutional and statutory obligation to preserve the original surveillance footage from the CPD in its entirety. To be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement custody is perhaps one of the most critical and highly contested issues in this case. The footage that has been produced by the Commonwealth is rife with issues that call into question its accuracy and forensic viability of the CPD's video surveillance footage obtained from the sally port on January 29th. The Commonwealth has produced numerous video files without any way to verify their authenticity. These video files include a file capturing the interior of the sally port garage with a 42-minute gap missing at the precise time that the feed would have showed an unobstructed view of the right rear taillight of Miss Reed's 6,000-pound SUV as it entered the CPD sally port garage. In spite of the fact that the Commonwealth claims the video surveillance feed is motion activated, the mid-trial production of an inverted video, that's funny, okay? The camera issue. If your cameras are motion activated and a big object is moving across the screen, that's when it does record. So for them to say a car was brought into the screen, it was parked, but no one was walking there, so it didn't turn on. Nope. That's a big nada. That's what it would have recorded. Let's see. The mid-trial production of an inverted video produced by the CPD in an attempt to save face for the gap in footage, which improperly depicts right as left and left as right, and falsely suggests that no one from law enforcement approached the right rear taillight, and a blurred-out video that obstructs what would otherwise be another clear view of the rear right taillight as it entered the Sallyport garage on January 29th. It is not a coincidence that none of the many cameras in the CPD Sallyport garage captured the condition of the right rear taillight upon its arrival at the CPD, and before the first pieces of taillight lens material were recovered by law enforcement at 34 Fairview Road. What is not a coincidence? It is not a coincidence that none of the many cameras captured it. The fact that the Commonwealth and its agent, the CPD, failed to preserve the footage in a forensically sound way and allow critical evidence to be destroyed is not a coincidence, and goes to the heart of Miss Reed's defense and credibility of some of the Commonwealth's most central witnesses. Even if ADA Lally was not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. Evidence in the possession of the police is Brady material, even if the prosecutor is unaware of it, so the prosecutor has a constitutional duty to inquire. Following the February 2nd, 2022 preservation order, ADA Lally should have and a diligent prosecutor would have promptly notified CPD to preserve any existing footage and inquired about whether the DVR system overwrites or deletes old data. The certificate of compliance ADA Lally signed and filed with this court specifically includes a representation that the prosecution made a reasonable inquiry to disclose and make available all discoverable evidence. ADA Lally did anything but, and the Commonwealth is responsible for the resulting loss of this critical exculpatory evidence, which cannot be cured short of a dismissal in this case. This is their crux of this. It was so critical to this case, the fact that they lost it, that you have to dismiss the case with prejudice. I can imagine that phone call. Yeah, this is ADA Lally. What, if any, video do you have of the... The Commonwealth withheld exculpatory statements by McCabe in flagrant violation of its obligations under Brady Rule and 14. The Commonwealth withheld the May 10, 2024 exculpatory statement of McCabe, in which she denied traveling to the personal residence of the first responding officer, Sergeant Lank, on January 30th, 2022, the day after O'Keefe's death, and then claimed she went there with Carrie Roberts to pick up Roberts' daughter. Clearly, the Commonwealth was required, pursuant to their Rule 14 discovery obligations, to disclose the false statement made by McCabe to Lieutenant Tully regarding her visit to Sergeant Lank's house. Rule 14 requires automatic production of all statements of persons the Commonwealth intends to call as a witness, and any facts of exculpatory nature. The Commonwealth's decision to preemptively reveal impeachment evidence uncovered by the defense to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a clear-cut violation of the Commonwealth's constitutional obligations under Brady and its progeny. Yeah, the way they spell it out, that looks really bad. B. The Commonwealth's egregious and repeated discovery and Brady violations require dismissal of this case with prejudice. When the Commonwealth fails to comply with its discovery obligations, the court has the ability to impose remedial sanctions. For failure to comply with any discovery order issued or imposed pursuant to this rule, the court may make a further order for discovery, grant a continuance, or enter such other order as it deems just under the circumstances. Clarifying that the rule clarifies that the permissible orders include dismissal of charges with or without prejudice. Emphasis added. Such remedies include the exclusion of evidence and even the dismissal of the criminal charge. Oh, water is delicious. All right. Here we are. There is no question that on the failure of the Commonwealth to comply with a lawful discovery order, a judge may impose appropriate sanctions, which may include dismissal of the criminal charges. Dismissal is appropriate. Dismissal is the highest one, by the way. That is the very top the judge can do, is dismiss the charges with prejudice. There are other steps that are allowed in there. Obviously, defense is going to say, we want the greatest. That's the only way to fix it. It's possible that a lesser solution could be met. But I don't know how in this case. Sharky, 14 months. Thank you very much. I agree. There are problems here. I don't think we'll ever know what actually happened. Dismissal is appropriate as a remedial sanction, as a way to cure any prejudice caused by the violation of discovery obligation and ensure a fair trial. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable. It's irremedy. The key word is remedy right here, right? Remedy. Irremediable. Irremediable is how I think I'm going to say it. Harm to the defendant that prevents, that means they can't fix it, by the way. That means it's beyond repair. There's no remedy to be able to continue in the trial. That prevents the possibility of a fair trial. The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the rights of defendants against the necessity for preserving society's interest in the administration of justice. Here are the citations. First, Where the prosecutor fails to disclose evidence the defendant is entitled to receive, and the defendant is prejudiced by the failure of disclosure, a motion to dismiss should be allowed when the defendant can make a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. That's the showing is right here. Alternatively, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to a presumptive prejudice. In such circumstances, dismissal would be appropriate if needed to create a climate adverse to repetition of that misconduct that would not otherwise exist. This is basically saying you need to kick the case out and dismiss it with prejudice to show the state that's not allowed, to prevent it from happening for somewhere else. So there's the one reason is because, hey, you wouldn't get a fair trial in this case if we don't kick it out. And the other one is, and it's so bad we need to kick it out with prejudice because if we don't, the state's just going to keep doing this with other cases. Dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated non-compliance with its discovery obligations. Given the extreme governmental misconduct in this case and the irreparable nature of the harm to Miss Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the Supreme Judicial Court. The Commonwealth has failed to disclose evidence that was obligated to disclose to Miss Reed, which severely prejudiced her, such that a fair trial is not possible. Here, now, the argument on the other side of this is, okay, the first trial was not fair. We're going to redo it, and this time you'll have that evidence up front. Because that would be a lesser solution than just dismissal with prejudice. But at the same time, if you're saying that the previous one wasn't fair, you've got to find that, I don't know, they went through the whole trial. Jeopardy didn't detach. It was a mistrial, apparently. Crypto tax lawyer, welcome to the gallery. I don't envy your job this time of year, especially looking at my minuscule and many cryptocurrency transfers, most of them under $1. I probably should not be playing with cryptocurrency, but especially in tiny amounts like that. My accountants, I haven't told her yet. I haven't told my accountant yet that I have pages and pages of stuff. Anyway, here Miss Reed has been irreparably prejudiced by the Commonwealth's discovery violations in this case. The first trial resulted in a hung jury precisely because this was a close case. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Miss Reed was constitutionally and statutorily entitled, the result of the trial may well have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defense in a concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witness in this case, including Sergeant Buchanan, McCabe, and Higgins. Moreover, the Commonwealth's continued piecemeal production of exculpatory video footage, which has, by definition, been in the Commonwealth's possession since January 29th, 2022, is a flagrant violation of the Commonwealth's constitutional and statutory obligations under Rule 14 and Brady. I don't know how the judge could continue without taking action on this allegation, because it's from the Commonwealth's own statements that they're admitting they did this wrong. They're saying that the video was auto-deleted within at least 30 days, so they had to have had it in their possession within 30 days. They have the obligation to turn it over. They had it, so they had to have gotten it in that time, and they didn't turn it over. You can't just show up with a video and be like, oh, oops, found this, let's use it. Or, oops, we forgot to show this to you. You could have used it, but now you can't because trial's over. It is well established that suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material, either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. The Commonwealth may not withhold such evidence from the defense. To do so is not only a discovery violation under Rule 14, but also a constitutional violation. Furthermore, the Commonwealth's gamesmanship in withholding the exculpatory video surveillance footage from the CPD and failing to properly preserve this exculpatory evidence has irreparably harmed Miss Reed. To this day, the Commonwealth has not produced all the video surveillance recorded at the CPD on January 29th. Numerous camera angles and large swaths of time are missing. As a result of the Commonwealth's failure to appropriately image and preserve this evidence, video surveillance footage which should have captured the condition of Miss Reed's rear rear taillight at the time it was taken into custody from multiple cameras at multiple angles, has now been destroyed forever. Absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29th, the defense would have conclusive evidence that Miss Reed's taillight was cracked, not shattered, when it arrived at the conflicted CPD on January 29th, 2022. So defense is saying it was cracked but not broken. It was not shattered. And the video would have proven it. It would have proven it from multiple angles. Would have proven it from outside, would have proven it from inside, would have proven it from 6 ways till Sunday. But all the video magically, what's the word? Automagically disappeared. If the taillight was largely intact and only cracked, rather than shattering and missing 47 pieces, as Dighton, police officer Sergeant Barros testified he observed earlier that day, after Commonwealth claimed Miss Reed had struck Mr. O'Keefe, that evidence would establish Miss Reed's innocence and be case-ending for the Commonwealth. Crypto tax lawyer says, "What's up, RA? Just dropping in to say hi. I don't know how I didn't know this, but we're semi-neighbors. Raleigh, but husband from Kinston." Oh, yeah. Have a call. We'll be on the replay crew. Been waiting on this. Crypto tax lawyer, hello, fellow North Carolinian. Thank you very much for the super chat as well. Kinston's just down the road. All right. It would have been case ending for the Commonwealth, meaning that one piece of evidence is the smoking gun that would have shut down the whole prosecution. It should not be lost on this court that this video surveillance was destroyed in the Commonwealth's possession in direct violation of a preservation order. That's in bold and italics. It must be important. The video surveillance was destroyed by the Commonwealth's in the Commonwealth's possession. It's not saying that Adam Lally went and deleted it. It could be the police that deleted it, but Adam Lally had, because he's over the police in this, as you know, through this Brady coverage, he had the responsibility to protect it, and it was deleted. So the responsibility is passed up to him, and they can make that allegation that it was destroyed in the Commonwealth's possession after it had been ordered to be preserved. That's pretty bad. As a result, Ms. Reed is left without the ability to forensically examine the CPD's DVR system to determine whether the many random clips produced by Commonwealth in Discovery have been altered, manipulated, or tampered with, and whether other clips have been destroyed. The Commonwealth's failure to preserve and produce this exculpatory evidence, which includes the destruction of all original and native video surveillance footage and the accompanying log files, has irreparably harmed Ms. Reed. There is no lesser sanction that can cure the Commonwealth's failures to preserve this evidence. The no lesser sanction things, that's when you're telling the judge, look, you have to do the most extreme remedy. You have to dismiss this with prejudice. You can't just punish them and say, oh, we're going to take, one of the charges is going to be lessened. You can't go for, for second degree, you have to go for manslaughter instead or something. That's a lesser punishment. They're saying you can't do that. That won't fix it. You have to go to the more extreme measure of dismissing this with prejudice. Exclusion of the video surveillance footage at trial would undermine Miss Reed's defense because the footage itself is exculpatory. Yeah, you can't keep the evidence out and say it was just late, it can't come in, because defense needs it. Indeed, the very nature of the evidence is such that the exclusion harms rather than helps Miss Reed. The exculpatory evidence to which Miss Reed is constitutionally entitled is permanently lost. Therefore, the Commonwealth's misconduct can be remedied only by a dismissal of the case. Unsurprisingly, the Commonwealth is utterly unable to establish any chain of custody for the footage, let alone explain how it came to be inverted. Unlike the other video surveillance obtained by MSP in this case, the CPD video surveillance footage was never logged into evidence, and there were no reports documenting the recovery of the evidence, and there is no documentation regarding its chain of custody. That's bad. Even if this court disagrees that Miss Reed has been irreparably harmed, the Commonwealth's misconduct gives rise to presumptive prejudice that warrants dismissal. Presumptive prejudice. This is fun. Let's get into presumptive prejudice. The misconduct by the Commonwealth in this case was egregious, deliberate, and intentional. These were not innocent mistakes. The repeated and flagrant discovery violations engaged in by the Commonwealth and its agents were intentional and designed to bring about wrongful conviction. Here, at trial, ADA Lally, the Commonwealth, and its agents intentionally withheld video surveillance footage from January 29, 2022. The Commonwealth sprung inadvertent surveillance footage on the defense in the middle of trial, in violation of Rule 14 as well as its certificate of compliance, and then it compounded the violations by attempting to perpetuate a fraud on this court and the jury. By knowingly eliciting false testimony from Sergeant Buchanan on direct examination, the Commonwealth violated the ethical prohibition against presenting knowingly false evidence to the trier of fact. The inverted footage of Miss Reed's vehicle from this interior Sallyport camera was unquestionably a false account of the true facts, and the Commonwealth passed it off as an accurate depiction of the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the right rear taillight. The Commonwealth's deliberate attempt to use discovery violations to its advantage in an effort to perpetuate a fraud on the jury is the precise type of conduct that requires dismissal. Moreover, both ADA Lally and ADA McLaughlin were caught withholding exculpatory information from the defense at the first trial. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a gross violation of Commonwealth's constitutional obligations under Brady and its progeny. Even after the trial, ADA Brennan located exculpatory video surveillance footage, which was withheld from the defense at the first trial, and established that Higgins made a phone call at 1:34 a.m. outside the CPD. This exculpatory impeachment material was never turned over to the defense. And it's blacked out. Let me go back just for a second. When they're talking about under Brady and its progeny, Brady is case law. Some case law is so famous that it's just known by one name. Brady is such. Miranda is such. These are cases that are fundamental in the shaping of the legal system as we know it today. Those cases, when they first happened, were pivotal, okay, as to how things process going forward. But the progeny, what came after it, there were follow-up cases that helped shape and direct and guide and limit or expand, in some cases, those rulings. So every time it says Brady and its progeny, Brady is the first case that said, hey, you have to turn that over. And then the progeny might be, you have to include police stuff. That falls under your area. So that's where the progeny comes in. It's a fun word anyway. So we've got the redaction. The Commonwealth's repeated violations of its constitutional and statutory discovery obligations were calculated and intentional. This is another bold claim where they're literally saying you planned on doing this. This was by design. And were done in an effort to secure a conviction at all costs rather than pursue the truth. Indeed, as discussed above, the Commonwealth's misconduct has resulted in a violation of Miss Reed's constitutional rights so as to give rise to presumptive prejudice. The discovery violations in this case constitute a Brady violation and thus violate Miss Reed's due process rights. To establish a violation of the Brady v. Maryland, as incorporated into Rule 14, the defendant must demonstrate upon review that evidence actually existed. The evidence would have tended to exculpate, I added some extra syllables in that word, and that the Commonwealth failed to disclose it upon proper request. Okay, so let's break this apart because that's the rule, right? They have to demonstrate that evidence actually existed. The fact that it was recorded and on the machine is evidence that it existed because we saw some of it. The evidence would have tended to exculpate him. That means that it would have been sort of in their favor. And that the Commonwealth failed to disclose it upon proper request. I think all three of those are met. As discussed in Part 2A, all three prongs of the Brady inquiry are met in this case. Oh, good. So they agree with me, or I agree with them, as the case may be. Given that the facts give rise to presumptive prejudice, that means we can presume that there's prejudice. And considering the need to create a climate adverse to repetition of that misconduct, that means punish the state so they don't do it again to somebody else, this case should be dismissed. To allow this case to proceed to trial would create a climate in which these types of flagrant constitutional and statutory violations are regarded as permissible. Such an outcome cannot be tolerated by this court. The Commonwealth's clear, repeated, and intentional failure to comply with discovery orders requires an appropriate remedy in this case. Stop for just a second. Look at the Alec Baldwin trial. Look at the discovery violation that happened there. Look at the withholding of evidence. One little bit, okay? And that was enough to get the whole thing thrown out. Can't you, even if you're on the Commonwealth side and saying Karen Read did this and, she would be couldn't away with murder, can you not admit that these violations are larger and possibly arguably more intentional or more egregious than what happened with Alec Baldwin? Because the discovery violations concern a failure to produce and preserve exculpatory evidence, and because exclusion cannot remedy the violation, because that would hurt her, the only appropriate remedy is dismissal of the case. Because of the Commonwealth's egregious misconduct, including repeated and intentional delays in providing discovery, the withholding of material and exculpatory evidence, and failure to comply with court orders regarding discovery, Miss Read's constitutional right to a fair trial has been irreparably and irreversibly harmed. No proceeding against her can satisfy the constitutional requirements of a fair trial. The defendant therefore respectively requests this honorable court to order that the case be dismissed with prejudice. Dismissal, this is bold caps. Dismissal is the only appropriate remedy for the violation of Miss Read's Sixth Amendment right to trial by an impartial jury. Additionally, dismissal of this case is also required to remedy the violation of Miss Read's Sixth Amendment right to impartial jury. And here we have redactions. What is it about having the jury? What about the jury not being impartial is redacted here? Jury. Redacted, all of it. Notably, a juror may never be dismissed because of their views on the case or for reasons having to do with their relationship with other jurors. Instead, jurors may only be dismissed for reasons personal to the juror that have nothing to do with those views on the case or relationships with other jurors. Dismissing a juror because of their views violates a defendant's Sixth Amendment right to impartial jury. What juror was dismissed because of their views? The foreman? More redactions. Jury tampering. There's a fun allegation. Such as this is presumptively prejudicial. Hey, sorry, how are you doing? Is that chicken still cold?
No, I ate it.
You ate my... What? She ate my lunch. Literally. Jury tampering such as this is presumptively prejudicial and triggers a burden on the government to prove that the tampering was harmless to the defendant. The Commonwealth cannot do so here. As per Massachusetts law, courts do have the discretion to dismiss jurors when doing so would be in the interest of justice. Judges can do this at any time during the trial process, although the procedural burden and standard vary at various stages, post-impanelment but pre-deliberation. If a judge is alerted to a potential misconduct or affecting jurors, the judge first determines whether the material raises a serious question of possible prejudice. Someone's honking at my house. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Ooh, this is the juicy bits. This is the part we want. Juror misconduct, jury dismissal, jury tampering. Ultimately, Miss Read's Sixth Amendment right to an impartial jury entitles her to certain procedural protections when it comes to dismissal of jurors. Those procedural protections were not provided here. These constitutional violations, along with the egregious discovery violations discussed above, demonstrate the inherent unfairness of the proceedings against Miss Read and warrant dismissal of the case against her. In conclusion, this is the big summary, and it's usually very short, as this one is. For the above reasons, Miss Read respectfully requests that this honorable court grant defendant's motion to dismiss for extraordinary governmental misconduct with prejudice. Although dismissal is required and appropriate under the circumstances, in the alternative, the defense seeks and is entitled to an evidentiary hearing on these issues attendant to the Brady violations and juror interference. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ADA McLaughlin, ADA Brennan, Lieutenant Tolley, Chief Rafferty, Trooper Proctor, Sergeant Buchanan, Colleen Crawford, and other members of the CPD and Lieutenant Fanning. Just put them on notice. We might be coming to talk to you. This part right here, though, in the alternative, these are the lessers, right? The defense seeks and is entitled to an evidentiary hearing. Okay, so they're saying if you don't agree with this motion, we at least think we've done enough to prove that you should allow us to look further into it. Allow us to ask those questions. And this, see, they're not asking to talk to the jury here, right? I don't see any jury members on that list, unless Colleen Crawford is one. Who is Colleen Crawford? Did they forget to redact her name? Can somebody do a quick naming names and kicking butt? Oh, she's a tech person for MSP. Thank you. Okay, I just wanted to make sure that was not a jury name that was being outed there. And it's signed in true legal fashion with a hieroglyphic. Let's see. There's AJ. There's David Unetti. Robert Alessi. Oh, I like his signature. I think he used a Sharpie. He's got his black Sharpie out. That's awesome. You got the certificate of service that Miss Little sent it digitally. And then we've got the redacted version. Here are the exhibits, right? This is the affidavit. Now, let's see. This is an affidavit. We're going to read this one. This is an affidavit of Alan Jackson in support of the document we just read. So AJ is basically tacking on his, and here's what I think. Alan J. Jackson, Esquire, under oath, do depose and state as follows. I'm a partner at the firm Worksman, Jackson, and Quinn. I represent defendant Karen Reed, Pro Hoc Vice. That means he's an out-of-state attorney who's operating under permission of the court. Usually you have a sponsor or somebody who says, hey, I can vouch for them, and the court says, yes, I'll let you be an attorney here. I submit this affidavit on personal knowledge in support of defendant Karen Reed's motion to dismiss for extraordinary government misconduct. Personal knowledge. That means I've seen it myself. I have evidence. I have reviewed all the discovery produced by the Commonwealth in connection with this case. There is significant exculpatory evidence, which has been in the Commonwealth's possession since January 29, 2022, and was withheld from the defense at the first trial. The facts set forth in the instant motion to dismiss for extraordinary government misconduct are true and correct to the best of my knowledge. Attached hereto as Exhibit A is a true and correct copy of the Stoughton District Court's February 2nd order, allowing defendants' emergency motion for the preservation of evidence. Attached hereto is Exhibit B. It's a true and correct copy of this court's October 5th order, allowing in part defendant's motion to compel discovery. Part 7, which nobody knows what it is. Part 8, attached hereto is Exhibit D, I, J, O, and S are true and correct copies of excerpts of transcripts from the first trial. Attached hereto as Exhibit E, H, K, and M are true and correct copies of video surveillance footage from the Canton Police Department captured on January 29th, which were produced in discovery by the Commonwealth on April 4th, April 23rd, October 10th, and January 28th, respectively. Look at those dates, 2024, 2024, 2024, and 2025. Literally less than a month ago, a new video was just turned over. Attached hereto is Exhibit F, is a copy of the Commonwealth Certificate of Compliance, which was filed in this court on April 10th, 2024. Section 11, nobody knows, all redacted. Section 12, attached hereto is Exhibit P, is a true and correct copy of Lieutenant Brian Tully's May 29th, 2024 report, memorializing his May 10th, 2024 interview with Jennifer McCabe, which was not produced to the defense until June 4th, 2024 as part of NOD XLV. This report was not produced until after Jenna McCabe had already testified for the Commonwealth. Part 13, Part 14, both redacted. Part 15, on October 10th, 2024, after trial in this matter had concluded, the Commonwealth produced additional exculpatory video surveillance from the Canton Police Department, establishing that Brian Higgins made a phone call to some unidentified individual on January 29th, 2022 at 1:34 a.m. This video surveillance, I did not put that on the screen. I apologize. This is for nailing Sean, thank you. Stoughton. This is for nailing Stoughton. I apologize. I had one on the screen previously, and I didn't get it right here. That was the crypto tax lawyer. Thank you for the super chat and welcome. Shark, I think I missed you as well. I forgot to put things on the screen. Sean White, Stoughton, and then I said it right. We need to teach you to speak Massachusettsian if it's pronounced Stoughton. Okay, there we go. This video, let's see. This video surveillance footage, which is attached here to as Exhibit K. How do you attach video surveillance to a filing, a paper document? Was not produced by the Commonwealth until after trial on October 10th, 2024, in connection with NOD XLVII. Those are Roman numerals. After that many letters, I just don't do the math. Special Prosecuting Attorney Hank Brennan indicated that he located this video footage on some sort of electronic device in a box that was in the actual possession of the Norfolk County District Attorney's Office. We found this in our desk after trial. Hope you enjoy. Toodles. Signed, Hank. While he was conducting his review of the discovery in this case, the defense has set forth credible and unassailable evidence establishing that the Commonwealth has engaged in numerous and egregious Brady violations throughout the pendency of this case. The Commonwealth repeated constitutional and discovery violations, which have ultimately resulted in the permanent destruction of exculpatory evidence, as has caused Ms. Reed to suffer irreparable harm, and a fair trial is simply not possible. Video referenced as attached is hand filed in on USB. I didn't know that, Mildred. Now I know. USB attached. Use a Lally port to attach the videos to paper. Yes. What, if any, attachment do you find here? This, I don't know what came here. They didn't just black out the, see, everything before, we've got like lines excluded. There must have been a picture, something. That's more than text. Let's see, we went from 16. All of section 17 is blacked out. We can't even see the white space between the lines. That's how sensitive it is. We barely even know it was 17, but only know that because it was surrounded by 16 and 18. So even the 17 needed to be blacked out. Ms. Reed has suffered numerous and egregious constitutional violations as a result of the Commonwealth's brazen discovery and constitutional violations and juror interference, which denied Ms. Reed her Sixth Amendment right to a fair trial by an impartial jury. The interests of justice require that this court exercise its discretion to dismiss this case with prejudice. It is the discretion of the court to do this, but they have to do the right thing. In the alternative, the defense respectively requests that this court grant an evidentiary hearing, such that the defense can call witnesses to further establish through sworn testimony that Brady violations and juror interference have occurred in this case. If they do that, they literally would be saying, we're going to hold a hearing where everything we just spelled out in this document will be dragged out in painstaking detail from every person who was participating in this. And they will have to admit, because the facts are the facts, that in fact, those videos were taken from the police camera system and they were turned over to to Lally, and he did stuff it in the desk drawer and keep it there until after the trial. And once that testimony is on the record, that they have to do something about that. Signed and sworn to under the pains of penalties of perjury. Okay, that's a lot of alliteration. Let's try this again. Signed and sworn, there's our first alliteration. We've got the two. Under the pains and penalties of perjury, this 21st day of February 2025. So this was a week ago. It took a week for Judge Cannoni to black everything out with her Sharpie. Exhibit A. Now look, if you look on the side right here, I'm not sure if you can see my mouse, but we're about a third of the way in. We're a third of the way into the document. I'm not going to read everything going forward, but we're going to scroll through it a little bit because these are the exhibits. So you've got the Stoughton Division, District Court Department, Commonwealth, Plaintiff, Karen Reed, emergency motion for preservation of evidence. This dates all the way back to, let's scroll down here, February 2nd. This is when they said that the defendant is specifically requesting this court to order that such notes are not to be destroyed upon completion of police reports. So any notes have to be saved. All turret tapes from any local police department and the Massachusetts State Police regarding this matter. All 911 recordings, all trace evidence, fingerprints, DNA, blood, saliva, other bodily fluids, all physical evidence, including anything present on or near the decedent at the time his body was recovered, everything. All grounds, therefore, they say you have to preserve everything. And it's signed by, this was Mr. Yannetti that filed this motion back in February of 2022. Next exhibit, this is the Affidavit of Counsel in Support of Defendant's Emergency Motion for Preservation of Evidence. This is once again filed by Mr. Yannetti. Depose the state that the following is true to the best of my knowledge. I'm an attorney licensed to practice in Massachusetts. Here's my office address. On January 29th, I was retained to represent Karen Reed regarding the above captioned matter. So he's been with her since the day of. The requests for preservation of evidence made with this in this motion are reasonable and would prevent the destruction of potentially exculpatory evidence. It's almost like he could see the future. This was on February 2nd of 2022. I believe it's in the interest of justice for this court to allow the motion, sworn under the pains and penalties of perjury. Served to the court, signed by Mr. Yannetti. Exhibit B, defendant's motion to compel discovery. One more, all documents, 911 calls, call logs, tapes, complete recordings of the calls made by Jennifer McCabe, all crime scene photographs and videos taken in connection with this case, including but not limited to photographs documented the purported recovery of pieces of white and red plastic outside the residence. We've got some handwritten notes here. Allowed us to 1, 2, 3, 4, 5, 12, 13, 15 as amended. Denied as to 5, 6, as to numbers 6, 7, 8, 9, 10, and 19. So 6, 7, 8, 9, 10. Let's find those ones. 6, 7, 8, 9, 10. Which ones? 6 was denied. That's communications between law enforcement. 7 was denied. Communications between Trooper Proctor and some of the witnesses. 8, all communications. 7 was Trooper Proctor and witnesses. 8 was all communications between Canton Police Chief Ken Berkowitz and any of the percipient witnesses in the case. 9 was communications between Detective Lieutenant Brian Tolley and any percipient, I cannot say that word, witnesses in this case. 10 were communications between and among any law enforcement agents from the Massachusetts State Police and any law enforcement agents from the Canton Police. 14, also written confirmation from law enforcement as to whether the digital timestamps on photographs taken in connection with this case are accurate and correct, including but not limited to crime scene photographs and videos taken using the Nikon 6 with lens Nikkor Z24-200. It's got a zoom lens. That's the f-stop. Why do they put the lens in there? That's crazy. I mean, it's nice to know. That's awfully specific. And Nike D750. What's a Nike? I think they mean Nikon. All right. So that's what was asked for and what was allowed. Then you've got more motions. Affidavit of Counsel in Support of Defendant's Motion to Compel Discovery. That's his motion on the back end of that one, saying it's all just and true and we need it. Exhibit C comes in. Oh, look at Exhibit C. Isn't that beautiful? The whole page, the whole page, the whole page, the whole page. Exhibit C is a big nothing burger. Exhibit D is just for us. I'm sure it's quite interesting for the court. Pantufle, I'm not Team KR, I'm Justice for JOK, who will never get that simply because the investigation was botched and corrupt from the start. His fellow law enforcement failed him and KR. Pantufle, I agree. I agree that, I mean, I'm not one team or the other. But I agree that that the investigation failed the pursuit of justice in this case. So here you've got the court order, trial with jury before Honorable Beverly Cannoni. Looks like this was typed up on a typewriter. Didn't know they still had those. This is June 10th. This is transcript. This is court transcript. And it's let's see. I did watch the video. How much do you estimate elapsed? We watched the video on that timeline, 15 seconds maybe. This is Sallyport video, Mr. Jackson. The court. This is the last time, Sergeant. Would you please? Yeah, we're going to replay the video. You remember this. It appears that this video in about 15 seconds jumps 42 minutes to the 550 mark, correct? I don't know how much it jumps. Well, from 508 to approximately 550, approximately how much time is that? Approximately 48 minutes. 42 minutes, right? 42. Yeah. So that's the testimony about that missing video at the exact time that it would have shown somebody there. More transcripts. Exhibit E, USB flash drive. That's the video, Sallyport. Exhibit F, Commonwealth Certificate of Compliance. This is the state, Mr. Lally particularly, or actually Michael Morrissey is the signer here. Oh, well, it's Michael W. Morrissey, District Attorney, signed by Adam Lally. So he's the assistant. So it's got Morrissey's name on the top, and Lally is the assistant. In accordance with Massachusetts R. Crim P. 14A3, the Commonwealth indicates to this court that to the best of its knowledge and after reasonable inquiry, it has disclosed and made available all items subject to discovery pursuant to the law and or court order. The identity of each item provided is as follows. Here are the items. I through XXX of EI. That's a lot for those who are doing the math. That's a lot of discovery. The Commonwealth further recognizes its ongoing and continuing duty to disclose any and all discovery material obtained hereafter. This filing is made with the present lone exception of materials still undergoing mitochondrial DNA testing at the Bodie Technologies Lab. He says, you got it all. I turned it all over. Exhibit G is blacked out. Exhibit F, Exhibit H is a flash drive. Exhibit I, this is some more, let's see what day. Day 26 of trial transcript. So let's scroll through this. Mr. Lally. Courier new font looks like a typewriter. It's terrible. I hate it. This is the worst. The only font worse than this is Comic Sans Serif. All right. This is the... They're like, hey, can we watch it again? Yeah. Can we turn on the lights? Yeah. Is that the end of it, Mr. Lally? I believe so, yes. Is that the end of it, Mr. Gilman? Yes. All right. Lights on, please. Thank you. I'll allow it. So I have a copy of the printed docket. There's all that. Thank you, Your Honor. Jury present. Exhibit J. More. This is day 27. And we're not going to read all of this. This is... Did you report your communications to Mr. Lally? No, I did not. Were you shown any of the videos that you've seen here in anticipation of your testimony? Not during the first meeting. I did review a video during the second time. Yeah, it's fun stuff. So this is just the supporting documents of that. A lot. Oh, this is the word. I saw magically in there. Which the person in the video to the left, to the rear of the car, is wearing a black hat, correct? I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically. I can't testify to that. There's no magic about this. It's your testimony. I'm just asking you what you see. I don't see that, no. Let's go ahead and play it at this point. Okay. Good stuff. I loved these exchanges. Oh. It was just sustained. Thought I saw a bad word. Objection sustained. Another flash drive for Exhibit K. Exhibit L, all blacked out. We don't get to see that. And it's a long one. Page 3, 4. There's a blank page. This page potentially left blank. Exhibit M is another flash drive. So flash drives are going quick. Exhibit N, all blacked out. 1, 2, 3, 4, 5. This page left blank. Exhibit O, more, let's see, this is jury trial, testimony of Jennifer McCabe. So this might be a long one. Jennifer McCabe's testimony. Let's see how long this one goes. That's Michael Lank's house stuff. Got in the car. We're consoling Carrie. She might have run in to use the bathroom. Then you just drove away. How long were you there? It was about an hour sitting there. All outside. Yep. In the freezing cold. Yep. Okay, so that's that part. I'm going to need a new mouse wheel at the end of this. It's never scrolled so much. Lots of testimony with Jennifer McCabe. Exhibit P, as in Papa. Ooh, we got some letterhead. The Commonwealth of Massachusetts Department of State Police. Division of... And by the way, if you want any of these documents, please join Discord as the gavel drops. You can find all these documents over there if you want to peruse them and read all the trial transcripts and things like that and dig any further into this. Go back and use it for your own purposes. Please check out Discord for that. Amber's just dropped a link for Discord. If you have any problems with Discord as well, it's not my issue. No, just kidding. It's not my problem. There are some wonderful people over there that will help you figure out the system. It's worth putting some time into learning how it works, because it is a ton of data. And anytime you have a ton of data, there has to be a system and a method to track it and navigate it. And they have it in place. I think it's great. I even struggle with it at times, but anything you want is over there. And there are places to discuss it with other people. There's documents, there's calendars, there's video links to different hearings and proceedings. You'll love it. All right, so this is from First Assistant District Lynn Belland from Norfolk DAO. That's to him, from Detective Brian Tully about the meeting with Jennifer and Matthew McCabe. And it's on May 10th. Jennifer and Matthew McCabe arrived at the office of the Norfolk District Attorney's Office. Jennifer was provided a copy of her grand jury testimony regarding Commonwealth versus Karen Reed. Matthew was provided a copy of his testimony. They read the transcripts in a conference room and returned the documents. Jennifer requested to listen to her 911 call to Canton Police on January 29th. I played the audio file. Jennifer and Matthew requested to watch the Canton Police cruiser camera video that depicts both of them on the morning of January 29th. I played the portion of the cruiser camera that depicts the McCabes on that date. I asked Jennifer why her cell phone would have been in the area of the residence of Michael Link, Canton Police Sergeant, on January 30th. Jennifer stated she was with Carrie Roberts, who was picking up her daughter at the residence. Jennifer stated she did not speak with Michael Link while at the residence. Exhibit Q, all blacked out. 1, 2, 3, 4, 5, 6. 6 pages. Exhibit R, all blacked out. 1, 2, 3, 4, 5, 6. Exhibit S, all blacked out. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13 pages. And that brings us to the end of the 147-page document filed by Karen Reed's legal defense team about a week ago. All right, that was a lot of fun. we haven't read enough documents lately, but I apologize if I missed a bunch of stuff. We are let's see. We're going to jump back in court. We're going to be a little bit late, so let's see how to do this. Hey Amber, do I still need anything from Judge Simpson? I've got 4 hours of Judge Simpson right now from today. Is there anything I need right now, or can I drop that one off?
Call from
Angela.
Angela, how are you doing?
I'm doing good. How are you?
I'm hungry.
Yeah. Well,
I missed my lunch.
Wow. 147 pages. I don't know if you saw, but appeal to the federal court is 699 pages.
That's more.
So that's more, yeah. But a lot of it is like trial transcripts, a good chunk of it. So yeah.
Yeah, it's like the first third is probably useful, and the rest is all just exhibits.
Yeah. I am. I can't wait to see like how the judge will react. She has to dismiss the case, but on the other hand, we all know how corrupt she is. It's no longer a secret that she is Commonwealth biased towards Commonwealth.
Well,
maybe not corrupt, but very, very biased.
The thing is, this is not about who done it anymore. This is a procedural error that is big enough that it should cause a dismissal with prejudice. And I mean,
Yes.
it's like, I mean, in Alec Baldwin's case, I thought there was plenty of evidence that he might be able to be convicted in his trial. And there was a procedural error. There was something that was done that was willful on the part of the prosecution, and it's significant enough that it gets dismissed with prejudice. There's a reason that remedy exists, and that is to preserve the rights for other people in other cases, as well as preserve the rights for Karen Reed. In this case, they say there's no way you can fix this. You can't give her a fair trial, and you can't just tell the state, "Oh, it's all right. We'll just do the trial over again. We'll just do another trial, and it will all be good." And because that's no fair. That gives them too many bites at the apple, and it doesn't punish them for their bad actions. And I believe there are bad actions that are exhibited here.
And Brennan did as much, reveal in court that they do have the whole video, the whole 24-hour video footage on someone's computer, and defense asked asked in a motion, and the judge denied that motion for defense to get access to the whole video with metadata and hash values.
Man.
That's crazy.
That's not even
and
mentioned
even
in this.
denied no, because that ruling came out like this week, I think.
So what that basically adds to it
came out this week.
Is instead of pointing the finger just at Lally, it then more directly, because this one doesn't point at the judge much at all. There's very little shade thrown at the judge for this. It could be in some of the blacked out areas, which I wouldn't be surprised if those are the areas she did redact. But that's basically saying that the court is colluding in these bad faith actions. Because
Alessi called her out on Tuesday. He straight out called her out.
Yeah,
I don't know if you watched it, but it ended up in a boxing ring. The hearing ended up in a boxing ring, and the winner is yet to be determined.
Yeah, but the judge is the referee, so we've seen how she's ruled so far. I will say one thing about her: she has been consistent throughout this trial. She's been consistent in what she's done. But Angela, we've got to wrap this one up. I've got to step away, eat like 3 bites of chicken, and start a new live stream because
I gotta go and sorry for being absent, but I have been busy studying. I have an exam tomorrow, so this this was a nice break. Thank you so much for going through it. So I gave
you 2 demerits for your absence. So.
Yeah. Thank you. Bye.
Right, we'll see you. Bye. That's great. Absences are noted. They're noted. All right. We obviously, there's a lot to talk about this, and I'm super excited to hear. I don't know. Maybe I'm not sure if Rob's going to do a Friday Night Frenzy this week, talking a little bit about this motion. He's been following the Karen Reed trial pretty closely. I'd like to see the legal analysis. Obviously, Ian Runkle has been doing a lot of this. Brandy Churchwell, Melanie Little, Peter Tragos, Emily D. Baker, some great commentaries and commentary minds and legal minds of the LawTube and LawTube adjacent world have been following this closely. So I'd like to see how this one shakes out and how everyone else views this. For me, I like to think I don't have a dog in the fight, right? I haven't planted my flag on one side or the other on this one. I think that both sides have made mistakes. There are things I like and don't like about the different tactics they've taken. I see there's some problems. I mean, I've got to. I keep my Stop and Shop evidence collection bag right here because there's some issues with this case, and I think that needs to be brought up. You can't just overlook those. But anyway, I can't wait to hear what they have to say. With that said, we're going to drop this one off, and we're going to do a quick break. Kurt covered it. Melanie Little. Oh, Melanie Little. Kurt just covered it in Mel's channel. That's awesome. Brandy has great analysis, which is great. Do I have a leaf blower handy? Just in the other room. Yep, that's good. So here's what I suggest, and I'd encourage this if I could. This is a hot button trial. with some fiery people on both sides. I'm not saying don't listen to those people, but when you listen to them, try to, if you want to continue the conversation, try to do it in a respectful way. I think there are things that we can both learn from each other on both sides of this case. I think there's some important issues that have to be answered. There's some legal issues that have to be answered in the preservation of justice, and sadly, at the end of this case, I think there are going to be some losers, and I would hate to see that the justice system itself is the loser, meaning that we lose faith in the justice system. So I think that does need to be corrected. It doesn't necessarily mean it ends with it being thrown out. I wonder how it's going to be handled and addressed, but it has to be addressed. It can't just be swept under the rug. That said, please continue your conversations here and elsewhere in a respectful manner. I think that helps us as a community as a whole. I think it gives us more legitimacy, I think, in requesting access when the court doesn't view what we do in asking and seeking access to courts as a circus or a sideshow. So I think most of us want justice, and that's our main reason for going there. All right. That said, we're going to portal over. I'm just creating right now part 8 of the Todd Mullis trial. We're going to zoom to catch up on what we missed. Give me 6 minutes. Does that work? It will start at 2:30. We're going to pick up in the afternoon of what happened. I just made the new file right now. Going to portal us over. Still doing YouTube-y things. All right, portal's set up. We're going to jump back over and follow the rest of the Todd Mullis hearing today. It looks like we've got this guy on the stand. Was he the last guy we were talking to?
System?
Yeah, I think he was the last guy we were talking to. So we'll come back with him. It's going to be a busy day. Remember, again, tonight at 8 p.m. tonight, we have the podcast right here on this channel. It's just another video that you guys can watch and participate in. It's live. Thomas and I will be here entertaining, or I don't know. I like to think it's entertainment. So please come tonight. It'll be wonderful. Not Relevant podcast right here. Tonight, when you go home, you can talk to the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in about 3 minutes. 3 minutes. With part 2 of today's coverage of the Todd Mullis trial. Thanks, guys. Have a good one. See you.